Afternoon, Judge.
Good afternoon, Mr. Brown. Can you see and hear me okay?
Absolutely. It's very clear, very clearly. I've never done one of these kind of semi-hybrid, some people out, some people actually in the courtroom. This is going to be interesting to watch.
Well, I hope you're right. I hope it is.
Well, I hope you don't do like I did in my last Zoom mediation and drag people from one room to the other inadvertently. So we all gain skills.
We all gain skills. Well, let's hope we refine the skill today. All right.
Okay.
Good afternoon. This is cause number 20-130, JNL versus LNL. And let the record reflect that Mr. Sanders is here on behalf of the plaintiff, Mr. Leister here on behalf of the defendant. Mr. Brown is appearing online via Zoom for the intervener. Do we have any other counsel?
We do, Your Honor. Julianne Morris with my firm is also here.
Hi, Ms. Morris.
Your Honor, Richard Schmidt, local counsel for the plaintiffs, is here, and also my paralegal, Beth Foley.
Thank you, Mr. Sanders. All right, I believe that we are here today on LNL's motion to stay the injunctive relief requested by the plaintiffs. I'll let the parties know that I have read the filings, the responses, the response to the response, and the response to the response to the response. I've read all of those, so I think I'm going to be able to save us some time. Let me repeat to the parties what my understanding is of the request today, and so that y'all can correct me if I'm wrong, and we can narrow any of the issues that maybe I'm not fully apprised on. My recollection is that upon the filing of the petition in this case, the court had granted a TRO. We set that for hearing in August. At that time, there were several agreements. One was that the TRO would be extended until today, and that provided for some injunctive relief regarding about 4 or 5 things regarding the foreclosure on real property, on personal property, enforcing any liens, transferring, moving, destroying property, documents. That matter was extended by agreement until today, and I believe that the parties have already participated in a mediation, which was unsuccessful, is my understanding. Is that correct?
That is correct.
Okay.
It is correct between these parties, between my client and Belton Oil, Ms. Brown's client. We reached a resolution.
Okay, good. Excellent. I was unaware of that. Okay. And I think there was also an agreement back on August 13th that there was a setting on the motion to compel arbitration. And I believe that's set in 2.5 weeks on the 12th. Is that correct?
Final submission on the 12th. Yes.
Correct. Okay. And today's relief requested by L&L is to lift the temporary injunctions contained in the TRO that was extended until today. Is that correct, Mr. Leister?
Your Honor, I would say it a little bit differently. So the relief sought today by our clients, by the defendants, is to stay proceeding forward on a hearing on a temporary injunction. We believe the arbitration provision and the law, frankly, regarding arbitration, when that is an issue, precludes the court from going forward and hearing a temporary injunction. So I'd say it slightly differently, but I think the net effect would be the same.
Right, but you would agree with me that we haven't gotten to the issue of arbitration yet. We're going to do that on October 12th.
It's going to be dealt with by written submission at that point in time. You're right.
Okay. So was there not an agreement between the parties from August 13th until today, or until the court takes up the motion to compel arbitration, that if we use the case law language, to have a status quo of nothing's going to change until, first of all, we have mediation, and then we take up, if we have an unsuccessful mediation, then we take up the arbitration? Was there not an agreement or a meeting of the minds on that?
There was an agreement to push the hearing out on the temporary injunction, and during that time period to extend the TRO. When we filed our original pleading, in this case, we filed an answer and a motion to stay. I then filed a new motion to stay because I think the law supports, frankly, staying, moving forward on the injunction proceeding that the court has set for today. And that's what's set forth in both our motion for stay as well as the reply that we filed this morning that I think the Senate court coordinator will provide to the judge.
Yes, okay. And so what you're seeking to have, it's maybe terminology, stay the proceedings, but in effect, lifting the order that prohibits or prevents your client from enforcing liens, moving, transferring documents, all the things that the court had granted in its temporary order is really what was the subject of the plaintiff's request for an injunction. Is that correct?
Again, Your Honor, I would phrase it differently. I'm not seeking to lift the order. I'm seeking to ask the court to stay moving forward on the temporary injunction. I think under the law that the TRO, which was extended, would then expire by its own terms.
Correct. So there would be no restrictions on your client at that point. And so your client would be able to enforce a lien, would be able to transfer documents. There would be nothing preventing him doing that.
That would be if the court were to stay and the TRO were to expire by its own terms, that would be correct, Your Honor.
Okay. Okay. I just want to make sure that that was my understanding, and it is. Okay. All right. So, Mr. Sanders, do you want to respond?
Very briefly, Your Honor, I think that the law is not the way that the defendants represent it to be. The Fifth Circuit, which of course is persuasive authority, not binding authority, but the Fifth Circuit, after a case that they rely heavily on, said that in a situation like this, a court that has not yet ruled on the issue of arbitrability can enter a temporary injunction to maintain the status quo. That case is Janvey versus Algieri, cited 647 F. 3rd, 585. I have copies of it. We need to get it out. But briefly, Your Honor, this is Janvey is the receiver dealing with the Allen Stanford Ponzi scheme, and he filed litigation against some employees. The employee said, you can't get a temporary injunction because we have arbitration clauses. And the court, the Fifth Circuit said, no, a temporary injunction can go forward because the arbitration issue has not yet been decided. And the court recognized there is a split among the federal circuits and said it could go forward. Here in Texas, the Frontera Generation versus Mission Pipeline case, 400 Southwest 3rd, 102, as a Corpus Christi no petition case, recognizes, again, a split among the Texas Intermediate Courts of Appeals. Recognizes the ruling from the Janvey case and holds that a temporary injunction can, in fact, go forward while the motion to compel arbitration is pending, has not been ruled on. And the Iowa Court of Appeals recognized that rule in 230 Structured Capital Resources versus Arctic Cold Storage. That is structured 237 Southwest 3rd, 800. And I have copies of those cases if you would like.
Sure, I'll take copies of those. I see that they're cited in your reply or your response, but yes, if you have hard copies, I would.
And we cited other cases, Your Honor, but I think this pretty much covers the waterfront of why you can go forward to that.
Thank you, sir. All right, Mr. Leister.
Yes, Your Honor. As I looked at the response filed by the plaintiffs, they in essence made two general arguments. One was a waiver positioned by the fact that we agreed to reset the hearing on the temporary injunction for today. And that is nowhere near the type of conduct it takes to be able to waive an arbitration.
And I'm not concerned with the arbitration because it's not before the court. I guess really my concern is we're 2.5 weeks away from the court deciding whether or not there is going to be arbitration. I think that's going to drastically, that decision is going to really make the decision here. It's going to decide it for us. So if I grant the arbitration, then I think the law is pretty clear on that.
Right.
If I don't grant it, I think the law is likewise clear on that. So I guess my question, I'm curious as to the timing of wanting to stay the injunctive relief when we're 2.5 weeks from the ultimate issue in this, at least the pretrial issue of this, is whether or not there's going to be an arbitration. Am I wrong in that?
I understand the timing issue. I really do. The issue, and I know the court's read our motion as well as the supplement, which frankly contains the affidavit from the bank president, Mr. Williams. I mean, this is frankly no different than if somebody else off of the street had bought the note and the security agreements and the deeds of trust and what went along with that. Could the court come forward and preclude that party who then owns the note, owns the security agreements, could the court come forward and preclude that party from enforcing those rights? I mean, we tend to get a little bit caught up in the fact that there is a contract for sale that has the arbitration provision. But if the bank had chosen to sell the notes and the deeds of trust and the security agreements to the next door neighbor, the people who own the property next door, and so that they had those rights, would the court be able to then preclude that party from foreclosing in the event that the debt was not timely paid? And there's no question the notes are in default. My client is in a situation where it is hamstrung as far as being able to go forward with, frankly, the contractual rights or the rights that it acquired when it purchased the notes and the deeds of trust, which are in default. They can't go out and finance the property. They can't raise capital in any of those ways. That's almost frankly separate and apart from the arbitrability issue. And you know, my client would like to have the ability to do that if they so chose to do that. I mean, they have that right, frankly, because they purchased the notes and the deeds of trust. Now, practically speaking, it does make a difference, I think. They're just like a third party having gone out and done it. And regardless of what the court decides on arbitrability or not, my client owns those notes and deeds of trust. They have rights to enforce those notes and deeds of trust. To me, the issue of arbitrability or not doesn't impact on the fact that my clients actually own the notes and deeds of trust and have rights to be able to enforce those pursuant to the loan agreements and the transfer of lien agreements between themselves and the bank. They own them. They have a right to enforce them. They're in default. They should not be precluded from doing so regardless of what the court decides on the issue of arbitration.
Would they be able to do that during arbitration? If your motion was granted today, would they be able to do all these acts during arbitration? If arbitration was ultimately granted?
There's nothing in the contract that precludes them from doing that because they've gone out and just like a third party, they went out and purchased the notes and the deeds of trust. And the resolution for that is if the plaintiffs want to solve that problem and pay the debt, then they can end up having it back. I mean, as far as the real property and issue, if they want to pay my client for the balances due on the notes and deeds of trust, which is about $480,000, then they can solve the debt and they can own that property again. But at the end of the day, my client has gone out and purchased those. They have rights to enforce those separate and apart from the issue of the arbitrability issue.
But those issues are going to either be resolved in arbitration
Perhaps.
or in this court. Correct? I guess maybe I'm oversimplifying it, but I think of a homeowner and the mortgage company. Mortgage company has the same rights that your clients would. Be able to foreclose, be able to transfer, be able to sell, and they default, a homeowner defaults, and they seek to foreclose, and then the homeowner files a petition and a TRO. I mean, I have those all the time, and we grant the TRO, and then they go to they go to arbitration. And how's that any different than this situation here? The bank is not, or the mortgage company is not allowed to go and evict them before arbitration, not allowed to sell their home while they're pending arbitration. Am I oversimplifying it? And you're not going to hurt my feelings. You're not going to insult me if you say, yes, Judge, you are oversimplifying it.
No, I'm trying to figure out how to capture it. To me, it's one more step removed. To me, it's as though the neighbor to this property in Edgewood went ahead and went to the bank. But, you know, I've had my eye on that property next door. And I know they're in default on the notes. How about you sell them to me? And the bank goes ahead, great, I'll sell them to you. Pay me X amount of money, I'll sell you the notes, I'll sell you all the security instruments, the deeds of trust, everything goes along with that. And then you can enforce it. There's a default. And the neighbor who wants to have that commercial piece of property posted for foreclosure. Sure, could someone come in and file an ex parte application for a TRO and those kinds of things? Absolutely. But at the end of the day, it's pretty clear that my client owns the notes and the deeds of trust, and they're in default.
But they're also a named party in this lawsuit.
They are.
It's not like they're out. It's not like they're the neighbor in Edgewood or wherever who hasn't been served and hasn't been brought in as a necessary party to the litigation too, right?
Fair. I mean, but the hypothetical I was giving you kind of presumed that the people at J&L then decided to sue to prevent the foreclosure of the property by the neighbor who bought the notes. I mean, at the end of the day, the notes are in default and they're owned by, in this particular case, by my client L&L. Separate and apart from whether or not there's an arbitrability issue, they own the notes and they own the deed of trust and the security instrument.
Right.
They are, and they're in default. So, I mean, practically speaking, let me kind of maybe throw something else at me. Given where we are in September, my client, if they were to try to post that property for foreclosure today, could not foreclose in October. Good.
Just based on the timing of foreclosure sales, right?
So the earliest that could happen would be the November setting, which frankly would be after the court's going to take up the issue of arbitration. I mean, maybe the solution is stay the injunction. My client obviously can't do anything from a timing standpoint until the November sale date, which by that point in time, you'll either have the issue teed back up here for you, or you'll decide it's going to go to arbitration and the issue can be decided by the arbiter.
But you think that the court won't decide the issue of arbitration until November?
No. It's set for, the arbitration is set for submission, if I understood the.
October 12th.
October the 12th. So if the court rules within that time period, I'm not looking at the calendar to see the number of dates, but depending on when the court rules on that.
November's the earliest,
November's the earliest my clients get close to foreclosure anyhow.
and probably not likely, is what you're saying.
So practically speaking, I think the safest course would be to stay the injunction proceedings and then move on to the arbitration issue, which is really the crux of this issue in terms of what goes forward. I mean, I think the law, I think, is pretty clear when you have an arbitration provision such as this, that the court should not deal with the injunctive issues. And I know Mr. Sanders has cited the cases, or cited the court to some other cases, and I've not looked at their particular arbitration provisions. For example, as the court's aware, there are arbitration provisions that actually have a carve out for injunctive relief. In other words, we're going to arbitrate our disputes that we have. However, if the party needs injunctive relief, nothing in this arbitration clause precludes them from going and seeking injunctive relief. That's not the scenario we have here. The scenario we have here is if it relates to concerns, touches the subject of this contract, it's subject to arbitration. And frankly, my client wants to, when we get to arbitration, my client wants to enforce the contract. My client wants specific performance under the contract. That's all they want. They just want to do the deal and be done. A deal was cut on April 20 of 2020 and that contract for sale. They want to do that deal. That's all they've ever wanted to do. And so I think the safest course would be stay the injunction proceeding from going forward for the cases that we cite in our reply, and allow it to shake out however it shakes out when you make your decision on the arbitration, because we can't do anything practically speaking before then anyhow.
But that would allow your client, other than foreclosure, it would allow some other relief that could be immediate. Selling the business, transferring, destroying records. And I'm just talking, I'm not suggesting your client would do that. I'm just going back to the TRO, and I think that's going to be the request. And plaintiff can correct me if I'm wrong, but that seems to be the concern, is destruction of financial records, transferring, moving, destroying personal property. I mean, there's things that can be sold that don't have to be foreclosed on. Am I incorrect about that?
That was included in the TRO, but I'm happy to visit with my client, and if they'll allow me to stipulate that none of that's going to happen during the intervening time period before you get to the issue of arbitration. I mean, I don't think that's going to be an issue.
Yeah, and I agree that the scenario here is different than all of these cases cited. Through my reading, it was a quick and brief reading of the cases, but it seemed as most of the opinions touched upon the fact that the parties were in agreement that there was an arbitration, and that either it was the issue was going to be decided by arbitration, or they were actively involved in arbitration. And obviously the policy is for courts not to be involved and be an obstructionist to that. However, I understand the scenario here is that there is a arbitration clause in the contract that you seek to enforce and they seek to contest. So I understand that how the case law touches upon the arbitration clause, but that's why I keep saying we're not to that yet. And by y'all's agreement, I've set that on October. I think you're the ones that gave us the dates on those. Is that correct?
I don't recall, to be honest, Your Honor. I mean, to be fair, I just don't recall how that shook out. I think the court, my recollection was the court threw out the submission date, and then we worked back from that in terms of when responses, replies, that kind of thing would be filed. And it's going to be done by submission, which I don't know if the courts had to deal with arbitration issue disputes, but if it's non-evidentiary, it can be done by submission. If the plaintiffs seek to tender evidence and that kind of thing, it then makes it an evidentiary hearing. Submit affidavits, whatever. Arbitrability and whether or not the dispute falls within the scope of the arbitration clause is typically a question of law for the court. But if there's a fuss in terms of whether or not a quote factual dispute in terms of whether or not the arbitration was intended,
Duress, coercion.
Yeah, all that kind of stuff, that requires the court to conduct an evidentiary hearing. I don't yet know what position the plaintiffs are going to actually take, because I don't think they've filed anything indicating kind of where they're going to go. So I guess I raised that because that may end up changing kind of the manner and methodology in which the court ends up dealing with the decision regarding up or down during arbitration.
Okay. Mr. Sanders?
Mr. Leister really launched into arguing the injunction motion when we were talking about the stay was really started with this. And so I think I hear where the court is going in terms of whether the question is stay or not. Stay means you send me home. I don't get to put on any evidence today. I don't get a temporary injunction. I think Mr. Leister, I think he misunderstands the argument we made in our response to the motion to stay. We are not arguing that they have waived their right to attempt to enforce that arbitration clause. If between now and, unless something changes between now and when we file our response, that's not going to be our argument. Our argument is twofold. One, they've got the law wrong. We can go forward with a temporary injunction while the motion to compel arbitration is pending. And two, they agreed to put off the submission of the temporary, the consideration of the motion to compel arbitration until after the temporary injunction. it doesn't make sense for them to come in and say, wait a minute, we need to stay. They filed their motion to compel arbitration before the August 13th hearing. And they didn't come in that day and say, hey, Judge, you don't have any ability to do anything today. You need to shut this down. They didn't do that. That's because that's not the law. The law is we can go forward. And the last point would be, Mr. Leister says that these cases where a court can go forward on a temporary injunction while the arbitration issue is pending is only when arbitration clauses say the court can grant injunctive relief before the arbitration. The Thayer case on page 7 of the opinion specifically addresses this issue. And the paragraph that begins at the bottom of the column on the left, the Thayer court recognizes that there is a split among the authorities.
September 25th is National If You See Something, Say Something.
Hang on, Mr.
Show that protecting your
Is that you, sir?
You.
I'm going to mute you at this time. Go ahead, Mr. Sanders.
Recognizes the split among the authorities as to whether or not, in the absence of contractual language that says the court can proceed with a temporary injunction while before the arbitration, there's a split of authorities, but the court cites one of the cases that they cited, but then also recognizes Texas courts that have found that to be the case, and says we conclude you can go forward even in the absence of that contractual language Mr. Leister was discussing. And I believe we have essentially the same rule in the Janvey case. So at the end of the day, I think we can move forward, and we need to, because we don't know when Your Honor is going to rule on the arbitration issue. The court could decide it needs to happen every year. The court could be involved in some other proceeding and not able to immediately take up the arbitration issue. We could get I don't know how bad the hurricanes get up here where I'm from. They get really bad, and they can dump some water. We don't know if there could anything could happen that would delay the court from ruling on the arbitration issue. Without an injunction, they would then be able to go forward on some kind of a foreclosure. So let's take this in the order that we agreed to take it, which is injunction hearing today, and then after that, the hearing or the consideration of the motion to compel arbitration.
And Mr. Sanders, are you asking for additional injunctive relief that is more than what is contained in the current restraining order?
Don't believe so. I think our temporary injunction is the same relief. Well, I'll take that back. The TRO just said don't foreclose. The temporary injunction is not just don't foreclose, it's also don't post it for foreclosure. Don't file a foreclosure notice in the county clerk's office. So before we only had one. They had already posted, so we were just trying to stop that sale that they proposed to do on August 4th. Now, in addition to the not doing the foreclosure, we've also asked for issuing a notice of foreclosure, reporting any notice of foreclosure. I believe those are the two things that are over and above what we've done with the restraining order.
And just for the court's understanding, what is the state of the business at this time? Is it being operated? Who's it being operated by?
It is, Your Honor. So following the execution of the contract for sale, my client, LNA, L took possession of the business. They attended the consideration that's referenced in there, and they began operating the business. I believe they righted the ship. The business is making payroll, paying its bills, and it's functioning and it's operating, which it continues to do to this day, and in fact does so at the very property location that was the subject of the foreclosure. So it is operating, it has been operating, it will continue to operate out of that location.
All right, so there's no threat of foreclosure by another entity on your client at this time based on the business not operating or losing money?
That is correct.
Okay.
That is correct.
Yes, go ahead.
A couple other issues. So one of the cases cited in, frankly, the opinion handed by Mr. Sanders' report is the Feldman Max case. Happy to.
You may. Thanks, sir.
Yes, sir. And this is a case out of one of the Houston Courts of Appeals. And in fact, in that particular case, they acknowledged this split between the federal courts, but concluded that the precedent basically stands for the proposition that when you have an arbitration provision pending, that the temporary injunctive relief is improper while the arbitration issues are pending. It would be on the 7th page 7 at the bottom of that, where it says our precedent and Fifth Circuit precedent control this case. It talks about a split between the federal circuits on the issue, but it acknowledges the fact that their precedent stands for the proposition that when you have an arbitration provision pending, an arbitration pending, that it's improper to move forward with temporary injunctive relief.
Does that assume, though, that there is an arbitration pending?
I don't know the answer to that question.
Okay. And I guess that's kind of my focus now is obviously I want to get it right under the law, and everything seems to hinge on whether or not there is an arbitration pending. And it hasn't been submitted to an arbiter in these cases. Like I said, that was a quick and brief reading. It's obviously going to take more time, but Mr. Sanders? Well, I'm sorry, Mr. Leister, do you have anything else you wanted to cover?
I'm done, Your Honor.
All right, Mr. Sanders?
Your Honor, the Feldman versus Structured Settlement Capital Corporation, that case predates the Fifth Circuit's decision in January, where the Fifth Circuit said, we're going to go with the courts that say you can go forward with a temporary injunction while the issue of whether or not you're going to go to arbitration is still pending. And then he's essentially the argument that Mr. Leister is making is that Houston is smarter than Corpus Christi and Thayer. And I'm always going around the state and being told how dumb we are in Houston. So I think the better way to go is Jandy and the cases that have recognized that you can go forward with an injunction hearing before the issue of whether or not the arbitration clause is going to be enforced has been decided.
There's an interesting issue raised in this Feldman case that I think I need to bring to the court's attention. And what they're referring to is the fact that the courts in the Fifth Circuit have basically said trial court has limited authority unless the parties' agreement is to maintain the status quo. There's nowhere in the contract for sale where it talks about an agreement to maintain the status quo or an agreement to carve out injunctive. That's just not there as part of the arbitration clause. So I think our case is markedly different. We don't have such an agreement to maintain the status quo. set forth in the contract for sale related to the arbitration. Life goes on. I mean, that's why my client, when they bought the business and tendered money on April 20 of 2020, began operating. They took possession of it. They began operating. They have all the vehicles. They have everything. They're moving forward as if the contract for sale is in place, which they fully wanted to do. And so there's no separate agreement in there to maintain the status quo if a dispute arises and you go to arbitration. I mean, it's just not there. There's also no permit. So we think the appropriate thing to do would be to stay the injunction proceeding from moving forward and rule on the arbitrability issue as it presently has scheduled.
And Mr. Leiser, so you're telling me that your client does not want to maintain the status quo? That's what you're telling me.
So my client wants to maintain the last peaceful status quo before the TRO was entered. Absolutely. And so now, if the court's saying to you, when the court entered the TRO, that changed the status quo. And so if the question is whether or not my client wants to continue to be bound by
Which status quo, right? That's the question.
Yeah.
Which status quo, before the
Exactly.
TRO or after the TRO?
Exactly. I mean,
Then let me help you. After the TRO.
after the TRO. I mean, my client, if circumstances dictate, they want the ability to be able to borrow money against the property. They want, I mean, and granted, that's going to require them to foreclose first to get clear title. Frankly, the contract for sale contemplates my client getting free and clear title to the property, including for all the properties set forth in there, the assets, including this very piece of property in Edgewood. And so my client needs to be able to have clean title so that if they need to borrow money for working capital or to buy equipment or whatever, they can pledge that deal. But obviously that can't happen until they get free and clear title, because no bank is going to want to even contemplate that while that's up in the air. The question is, Your Honor, I mean, if you knew then what you know now, in terms of my client having bought the notes and the notes being in default and bought the security instruments with the court of entered the TRO, if you knew then what you know now, would that have happened? And so what is the harm to going back to what was the last peaceable status quo, which was my client owning the notes, owning the security instruments, and having a right to foreclose because the notes are in default? I mean, what's the harm?
I think Mr. Sanders is about to address that.
Well, again, Your Honor, he keeps arguing the temporary injunction, not the stay issue. He also keeps reciting things as facts that are in fact in dispute. So if we want to flesh that out, let's have the temporary injunction here. Here's another point, Your Honor. We go forward with the temporary injunction here. You either grant a temporary injunction, or deny it. If you grant it, they get to take it up immediately, and I'm sure they can raise this exact issue with the Court of Appeals. And if Tyler decides that that its prior decision in the structured capital case was wrong, Frontier is wrong, and in fact, Janvey, Fifth Circuit case is wrong, then they can correct that. Last point is, he keeps citing this Feldman case, and the Feldman case says, well, Fifth Circuit precedent says you can't do that. That was before the Janvey case came out, which the Janvey case says you can go forward in this situation.
All right, then what I propose is let me stand in recess for about 15, 20 minutes. Let me take another look at these cases, and then we'll resume.
Thank you, Your Honor.
Mr. Sayers, do you have a copy of the post of injunction? Yes. What else?
All right. Please be seated. Y'all, are y'all?
I think we need to go.
Was there an attempt at an agreement on any issues?
Here with your honor.
But no agreement's been reached? All right. We're back on the record in cause number 20-130, J&L versus L&L. All right, with regards to defendant L&L's motion to stay the hearing on the plaintiff's application for temporary injunctions, the court is going to deny the request to stay the request for injunctions. Court, after reviewing the case law provided by counsel, finds that the issue of arbitrability has not been taken up by the court, that the court is authorized and able to protect the integrity of any potential dispute resolution process that has been yet to be determined by the court. Court will entertain the request for injunctive relief to preserve any status quo that has existed in this case pending potential arbitration. Court finds that holding otherwise could result in the meaninglessness of any potential arbitration. Court finds that if there is a subsequent arbitration in this case, that the arbiters could be divested of the issues that they would be deciding. So the court's going to deny that. Is there any opportunity or any possibility rather that there could be an agreement regarding the injunctions? I have reviewed the proposed temporary injunction filed by J&L. Is there any possibility that there could be any agreement on that, and even curtail to any specific time that would be related to the court passing on the issue of arbitration?
I don't believe so, Your Honor.
You don't believe it?
I'm sure I understand the court's request. Say that.
Is there any possibility that your client, Mr. Sanders' client, could agree regarding the proposed temporary injunctions that they are requesting?
I don't know that we reached an agreement regarding a temporary injunction. What we were kicking around, Your Honor, was the potential that potentially, without waiving our client's position regarding arbitration, extending the TRO to allow the court to deal with the arbitration issue, and then potentially the temporary injunction issue following thereafter, the court decided to hang on to it as opposed to kicking it to arbitration. That does not mind that. What I think is going to end up happening is fairly likely that we're going to end up, while originally the arbitration issue was going to be decided by submission, I think what is likely to happen is that plaintiffs are going to tender some sort of evidence which will then tip it over and make that an evidentiary hearing. Frankly, on some, if not on some of the same issues that might be involved in a temporary injunction. But I was going to suggest was my client is amenable to extending the TRO presently in place till that time period or shortly thereafter, so the court can tee up the issue of arbitration, whether it's going to keep it or not. If not, then kick it to arbitration, because the court's going to keep it and take that issue at that time.
You may be surprised if I told you, but that is exactly what I was contemplating when we began the hearing, and I kind of questioned the parties about these issues. Mr. Sanders, your client's not in agreement with that?
Your Honor, we'd like to go ahead and nail down the temporary injunction. There's just too many perils that can occur if between now and supposed, when we actually have a hearing on a motion to compel arbitration. We just want to go ahead and get this issue put to bed. We can do it, I think, fairly quickly, and then we'll turn to the arbitration decision. Another point is, Your Honor, if your temporary restraining order is pending your decision on arbitration, if the court rules in our favor and says no arbitration, they're going to immediately take it up, and they're going to ask for the stay of all of the proceedings in this court, and we're gonna be back in the same problem, which is our restraining order has expired. So and instead of us, continuing this legal argument, I'd like to just go ahead and put on the evidence that I believe will support a temporary injunction.
And I appreciate that, but I'm not quite ready for that. Go ahead, Mr. Leister.
The flip side of that, or concern that my clients and I have, Your Honor, is if the court puts in place a temporary injunction and then decides to kick it to arbitration, then my client's kind of in that limbo land. And so what I frankly thought was the best solution would be to agree to extend the TRO, which my client will do, until the court rules on the arbitration issue. And then if we need to, if the court's going to hang on to the case and take the TI out here, if not, then the issue of injunctive relief, at least under the parties' arbitration clause, can be squared up and dealt with by the arbiter. And it's not, that issue is not precluded under the way the arbitration clause is worded in our particular contract per se. I'm trying to figure out a way to balance the equities to where the court can deal with the arbitration issue without us having to wrangle about the other. And like I said, my client's willing to do that. Kind of go back to the court's original question in terms of maintaining the status quo in terms of when the status quo will be applying, but maintaining that until the court makes its decision on the arbitration issue.
And I understand Mr. Sanders' argument about the TRO expiring if the court doesn't go the way of your client regarding arbitration. That would be an issue. How would you respond to that?
I mean, if the court doesn't go the way that my client wants to go, then my view would be let's go ahead and have the temporary injunction hearing at that point in time. That way the court can go ahead and address that issue right there and then. If he's entitled to a temporary injunction, he's entitled to a temporary injunction. If he's not, then he's not. He's protected throughout. In other words, I believe there's going to end up being an evidentiary hearing on the motion to compel arbitration, just based on what he's going to have to do in order to try to set it aside because it's unconscionable, fraud, arrest. Those are evidentiary issues. And to me, what could happen is the court could keep the TRO in place until it rules A on the motion to compel arbitration. And if it boots us out of this court to there, I mean, frankly, the court could deal with the temporary injunction at the same point in time, make its ruling at the same point in time. And that way, you don't have to worry about getting a cart before horse or whatever. Parties are protected. If they're entitled to a temporary injunction, they're entitled to a temporary injunction. If my client does not prevail on the arbitration, or frankly, for that matter, the temporary injunction, they can take both of those issues out to the power court of appeals. But I'm trying to find a way where we thread the needle where people are protected in this interim period until those hearings end up taking place.
All right, let's do this. Let's stand in recess and if I can see counsel for plaintiffs, counsel for defense in my chambers just for a brief amount of time. Mr. Brown?
Yes, sir.
I don't know how to bring you in chambers.
I'm fine, Your Honor.
Well, I'll tell you what.
I don't have a dog in this fight.
Well, if you want to go, I'll tell you what. I think I may be able to bring you. We'll find out.
Okay.
All right, we'll give it a shot.
All rise.
I got it. Just don't let it trip and fall. You can just go out the back there. Mr. Schmidt, you're not taking care of your client. You didn't know how to get out of the courtroom. See, Mr. Brown, I said there was no way to take you with me, but obviously there is.
This is the first time I've ever been drugged around personally by a judge. Most of them in these Texas can't pick me up.
Well, we'll see. I may not have a good connection in here though. So,
Well, you're doing fine so far.
well, we'll see how it goes. All right.
Tell the free state of Van Zandt I need to get you a booster.
I need to get something. Huh? You don't get things from the free state of Van Zandt. All right. We need to do one other thing here. we need to